Hey guys, we're back for part two. Let me just back up for a second. Again, we're talking about the correctional scenario now. And this is the one where the guard has a friend from high school who is now an inmate and is caught smoking, and smoking is prohibited in the area that he's smoking. And then I think it's written up that he may not be eligible for parole. So the question becomes, what standards should be in place from the prison administration to assist this guard with decision making, and why should they be put into place? And so again, it's going to go back to many of the same things we just got done talking about. This is another area of discretion. Now this is just an area where it seems like a matter somewhat insignificant, but the institutions may have some pretty strict rules about where you can smoke, if at all. But nonetheless, the officer's question here is what course of action should he take, and then of course what standards should the organization have in place. So again, we're back to the issue of discretion, which is the authority to make a decision between two or more choices. And in this particular case, it's whether or not to write up the behavior of an inmate, in this case for smoking. And so we're going to go back again to the same three areas that we talked about with the law enforcement officer, and that's going to be your code of ethics, your policies and procedures, and then your rules and regulations that are part of any correctional institution. They're going to have these just like in a police organization. So the Code of Ethics, the American Correctional Association's ACA Code of Ethics outlines formal ethics for correctional officers and other correctional personnel. And this is a link to their ACA Code of Ethics. And I'll also post this in my announcement so you can read that. And again, these are intended to offer some assistance to employees as they debate how best to handle a particular situation, whether it be in the correctional institution or in law enforcement. So again, we're talking about policies and rules and regulations, things like that. So policies are more general than procedures. Rules or regulations, policies are primarily guides to thinking rather than to action. We already talked about that. Agency values and mission statement, and so I've incorporated here the mission statement for the California Department of Corrections and Rehabilitation, and their mission statement is: we enhance public safety through safe and secure incarceration of offenders, effective parole supervision, and rehabilitative strategies to successfully reintegrate offenders into our communities. So a mission statement is basically a policy, okay? It's more general and doesn't necessarily deal with procedural issues. Procedures are more specific than policies. Procedures are guides to action. So, for example, how might a correctional officer refer an inmate to an infirmary? Those are procedural issues. What steps need to be taken? What forms? What notifications? Those are all guides to action. Okay, so procedures, again, are guides to action, just like they were in policing. Again, rules and regulations are specific managerial guidelines that leave little to no room for discretion. They either require or prohibit specific behavior on the part of the employee. And again, we're not necessarily talking about the police employee, but we're talking about the correctional employee here. Rules and regulations are mandates or prohibitions to action. So you have to act in a certain way or not act in a certain way. Example, inappropriate behavior with inmates, which would be boundary violations, something along those lines. Boundary violations is the behavior that blurs, minimizes, or disrupts the social distance between prison staff and inmates, resulting in violations of departmental rules. So, although it's not really apparent from this little scenario, but boundary violations could come into play in our scenario with the correctional officer if he takes that friendship into consideration, right? Because believe you me, that the other inmates will key in on this. But that whole idea of this behavior between the two of them, whether it becomes less professional, more friends, may in fact become become an issue. So boundary violations are something that one has to be careful with within an institution, and that's where people, the inmates, try to get the correctional officer not to do something or to ignore something or to maybe mail a letter for them or something like that. Okay, so boundary violations are closely tied to rules and regulations. And our scenario doesn't give us a whole lot of facts to that effect, but nonetheless, it's just something to keep in mind. And so we have rules and regulations to help the officers deal with these, how to recognize boundary violations, and how to deal with those as they're working with inmates within the institution. And so they can rely back on the rules and regulations and policies and procedures to seek support and direction in how best to resolve some of these issues that they may be confronted with. So that's about it for the rules and regulations. I think it's important just to know that basically the same set of guidelines are both for law enforcement and corrections. They are there to help guide the employee as they make these critical decisions. Some are designed to reduce the level of discretion that an employee has, and others may be to provide guidance on how best to resolve whatever issue is there. But nonetheless, these are all there for the benefit of the employee, to help them in the performance of their job duties so they are successful in what they do, and that the institution in this case remains safe and free of distractions and boundary violations. So very important, but the same basic concepts apply to both. So make sure that in your response you address that organizations have these rules and regulations, policies and procedures, code of ethics, and then also state why they have those. And it's really designed to help the employees as they navigate some of these rather challenging issues that pop up within the institution or within the field of policing. So you have a couple cases this week that you also need to look at. Ashcroft versus Iqbal. That's probably the more difficult case of the three this week. It really has to do with qualified immunity and treatment of inmates. As you remember, Ashcroft was Secretary of Defense under President Bush. And so this has to do with the incarceration of Muslim men following 9/11. Part of the key findings of that is the government, they must show actions of the government officers were for the specific purpose, policies of discrimination. So basically, Iqbal was claiming that he was discriminated against. Case ultimately went to the United States Supreme Court, and they returned it pretty much back to the lower courts to determine whether or not that the government acted with a specific purpose. In other words, was there a policy towards discrimination of Muslim men and how they were treated within the institution? So it's sort of a complicated case, but you can take that one if it interests you. But just know there's a lot of variables in there. They talk about qualified immunity and legal issues like that. The second case is Herring versus JUS. It's really the issue of good faith exception. The police arrested Herring on a warrant that should have been recalled, but it wasn't recalled. There was a snafu somewhere in the legal system, far away from the police department. I mean, this was a warrant in a different county. And so the officer stopped him, ran a warrant, determined he had a warrant, arrested him on that warrant, and as searching him incident to the arrest, he found contraband. And so the question becomes, should the contraband found during the search be legal, even though, come to find out later, that the arrest warrant should have been recalled by a court clerk in another county? So this is basically focusing on a good faith exception. And so you can take a look at that case. You might enjoy that one. The other one is Melendez-Diaz versus Massachusetts. This is the defendant's right to Sixth Amendment confrontation clause. The question here is, in this particular case, Melendez-Diaz was found with some narcotics. Instead of having the lab technician who analyzed the drug testify, they submitted a certified lab report. Melendez-Diaz was found guilty and he appealed it on the Sixth Amendment violation, saying that because the lab technician not testified, he was denied the ability to confront cross-examining witnesses, and the Supreme Court agreed. So that's what that case is about. So again, Ashcroft is sort of a complicated case. Herring is less complicated, so is Melendez. So I just throw that out there for your edification. Finally, the last thing, one of the things is this police probation combination, and trying to find out the basic principle of constitutional law and when a police officer can search, and when a probation officer can search, and ethical and legal challenges associated with searching a probationer's house, things like that. Remember that in order for a police officer to search somebody's house, they have to have probable cause to search. You can always have, obviously, exigent circumstances and or consent, but the constitutional issue here is probable cause. And probable cause is going to limit the scope of your search. In other words, if I'm looking for a television set, I'm not going to find a television set under the kitchen sink, so to speak. So one of the basic principles for law enforcement is that the scope of the search is going to be limited to whatever it is they're looking for. But the key principle, again, is they have to have probable cause. Whereas a probation officer does not need probable cause or reasonable suspicion in order to conduct a search. And this is often stipulated in terms and conditions of probation, where it gives the authority of the probation officer to search the probationer and his property anytime, typically day or night, without reason or justification, or no probable cause is necessary. Sometimes the ethical issue might arise in collaboration between police and probation, because maybe the police department or the police officer doesn't have enough probable cause, but the guy's on probation. And typically the way that is supposed to work, unless it's detailed differently in the terms and conditions of probation, because in some instances, under terms and conditions of probation, it may be worded that any police officer or any probation officer may search. But for those instances where it's just the responsibility of the probation officer, the police often will contact probation department if someone's on probation if they believe that somebody's dealing drugs or stolen property. They lack a sufficient probable cause, but they seek assistance of the probation officer in conducting the probation search. So sometimes that can be an ethical issue if the police officer may, obviously be less candid with probation officer in terms of what it is he's looking for. But the ethical issue, obviously, is that police need probable cause. Probation officer does not. Probation officers, the conditions for the probation officer are different. In other words, probation officer is a member of the court, and his job is to keep the probationer on his toes. And one of those ways to do that is to search without probable cause, to make sure that the probationer is adhering to terms and conditions of probation. Whereas a police officer is seeking evidence for criminal complaint, and so needs probable cause. So again, there is a collaboration that takes place between police and probation. It's done, hundreds of thousands of times every single day, where the police officer will explain to the probation officer the circumstances, and then the probation officer is often the one that has to make the decision as to whether or not he's going to go conduct a search or not, or whether he is the police officer with the authority to conduct that search. So again, searching a probationer's house, you can do it with the assistance of a probation officer. A police officer will do it if he has probable cause. But again, the scope of the search may be limited for the police officer because, basically you're seeking evidence of the crime, and you basically have to have an idea as to what you're looking for and where that evidence might be found. Okay, so this is really just going back to some of the basic stuff we talked a couple of assignments ago. All right, I think that's it. In the meantime, if you have any questions, please let me know, and I'll see you in Bright Space. Thanks, bye guys.